separate statement of undisputed material facts, numbers 1 to 26. Under paragraph 8.10 of the agreement, Alan Wagman would be personally liable for the debts and obligations of Esther and Frankie Inc. Whether Esther and Frankie Inc. is the alter ego of Christine Newman and Alan Wagman. Plaintiff submits evidence to show that Esther and Frankie Inc. is their alter ego. This is based on the minutes of Esther and Frankie Inc., which shows that Alan Wagman is the 100% owner of the company and the president and CEO. See Declaration of J. Shapiro, Exhibit 6. Further, the documents show that Christine Newman is the CFO. Also, defendant's evidence establishes that Esther and Frankie Inc. was formed as a method of hiding assets from Christine Newman's husband. See Alan Wagman's separate statement of undisputed material facts, number 5. As to the fraud claim, the plaintiff establishes tribal, which should be tribal issues, not tribal issues. We need to fix that. Whether the personal guarantee of Esther and Frankie's obligations and the loan and security agreement were representations that Alan Wagman would be responsible for Esther and Frankie Inc.'s obligations as the successor. Further, there is a question of fact whether Alan Wagman's representation of plaintiff that the formation of Esther and Frankie Inc. did not affect the liability of Esther and Frankie. See Declaration of Christine Newman, paragraphs 4 and 5. See Declaration of Carolyn Wagman, paragraphs 4 and 5. Did Alan Wagman, DBA Esther and Frankie, fraudulently transfer assets to Esther and Frankie Inc. to avoid his obligation to plaintiff? As to the motion filed by Carolyn Wagman for summary adjudication, that the tentative is to deny that we have the same tribal issues. All right, who wishes to be heard?
I would, Your Honor. Thank you. Your Honor, there are a number of comments I have to make about I would like to think about the tentative ruling. But first and foremost, the tentative ruling did not address the evidentiary objections which we filed on Friday with our reply documents. And a number of those evidentiary objections go to the heart of this motion and touch upon virtually every single issue that is here.
Let me stop you for a minute, okay? Because I did rule on evidentiary objections.
Their evidentiary,
okay.
Some of their evidentiary.
Hold on a second. I always rule on them, except when I don't get them.
We filed them directly to Department K on Friday. They were timely filed, and they were filed directly. We were told they were filed directly in this department. But frankly, based upon the tentative, I got the impression that the court had not read C&P reply.
Okay. All right. So you filed evidentiary objections.
We filed a reply brief. We filed evidentiary objections, and the evidentiary objections were numerous, but there are two important evidentiary objections to the fact that much of their opposition, the entire meat of their opposition, contradicts admissions that American Bancorp made in response to requests for admissions, signed, verified by Mr. Shapiro, the president of American Bancorp. In my declaration, I attached as Exhibit A and B, my reply declaration, attaching the request and their responses. These were requests for admissions which were propounded after the motion for summary adjudication was filed way back in November. They sought and received 2 continuances to oppose this motion for summary adjudication. But the requests for admissions are number 9 and 11. Number 9 says, admit or deny that you advised Ms. Newman to form a corporation, you, American Bancorp, Oscar Shapiro, to form a corporation. Response, admit. Request for admission number 11. Admit or deny that you discussed the formation of the corporation prior to it being formed. Response, admit. This scenario that the opposition presents and the tentative ruling they don't even have the right under the California Code of Civil Procedure to argue that. The scenario, as we now know that because they admitted the request for admissions, is that in February, March, after Esther and Frankie was being funded for a period of time, Mr. Shapiro suggested the formation of a corporation. At or about that time, this is all in the reply as well, Mr. Shapiro, on behalf of American Bancorp, sent out a notice of cancellation of the loan agreement with Esther and Frankie, the non-corporation, the non-corporate entity, and at a later point started funding Esther and Frankie Manufacturing Inc. after he had sent out documents to the Wagmans and to Ms. Newman, asking them to personally guarantee the obligations of Esther and Frankie Manufacturing Inc., which they declined to do. It's all in the motion and the reply. So there is no basis for the contention. By law, they cannot even make it. No basis for the contention that anything happened other than the fact that after there was the funding for Esther and Frankie, that stopped, it was canceled, there was funding then for Esther and Frankie Manufacturing Inc., and that funding was done when American Bancorp and Mr. Shapiro knew full well that my clients were not going to be personally guaranteeing the loan obligation of Esther and Frankie Manufacturing Inc. The tentative ruling also suggests that Alan Wagman would be the successor to Esther and Frankie. There's no basis for that. The provision and the guarantee to which the court is referring and to which the tentative refers says that this personal guarantee for Esther and Frankie, not the corporation, for Esther and Frankie, would be binding upon successors to Esther and Frankie. Alan Wagman did do business as the successor. There are in California law, there are individuals doing business as, there are limited liability companies, there are corporations, there are different entities. The corporation would be, at most, the corporation, Esther and Frankie Manufacturing Inc., would be the successor to Esther and Frankie. And that corporation's debts were not personally guaranteed by the Wagmans or Ms. Newman. So the only way the Wagmans or Ms. Newman could be liable for, and we're only arguing Wagmans here, could be liable for the debts of Esther and Frankie Manufacturing Inc. would be through the alter ego theory. The tentative ruling with respect to alter ego says, just as the opposition, the only evidence presented by the opposition, and the tentative confirms this, the only evidence is that Dr. Wagman was the sole shareholder and CEO of the corporation. There isn't a case in the history of the state of California where a shareholder has been held liable as an alter ego of a corporation simply because it's the sole shareholder and chief executive officer. The alter ego theory in California has set forth in numerous cases. In the main case, the Oakland, the Associated Vendors case cited in our moving and reply papers, sets a totality of circumstances of 15 or 16 areas where they have to establish in order to establish alter ego liability. They haven't argued one of those. But most importantly, they ignored the main argument of our motion on the alter ego theory, which was that with respect to alter ego, Dr. Wagman cannot be held liable because it has to be the person who was the actor who acted in bad faith. It has to be the person who was stealing from the corporation, using it for personal expenses. It has to be the person who created some corporation designed to defraud people, which we know can't be the case here because by law they are precluded from arguing that. The tentative says something about Christine Newman perhaps being the alter ego. That's not even part of our motion. The tentative says the same triable issues with Carolyn Wagman's motion, but Carolyn Wagman can't be the successor liability, successor to Esther Frankie. She wasn't even part of the corporation. The tentative mentioned that Carolyn Wagman, that there were the same tribal issues with Carolyn Wagman as with Dr. Wagman, but she had absolutely no involvement in the corporation. In their opposition papers, they said she went to lunch with Mr. Shapiro on one occasion. There's no alter ego under California law for going to lunch with somebody. So, Your Honor, our position is that when the court is able to review the reply document.
Let me stop you. I'd like to, you have your reply with you?
I have everything, yes.
I'd like to get the reply and the evidentiary objection. Some of these things went out for scanning. There's a new system here in terms of scanning documents and preparation to do everything where I can view it on a screen as opposed to having the hard copies. So documents have been unfortunately taken and sent down for scanning, and I don't get them back in time. Can you provide the court attendant with a copy of your reply and the evidentiary objection so I can read it and rule on those objections?
Yes,
I'm taking the matter under submission.
okay, they are whole punched